May it please the Court. Your Honor, my name is Sam Goldberg, and I represent Plaintiff Mr. Brian Tristan. Mr. Tristan is asking this Court to deny the motion to dismiss by the defendant because the defendant has established minimum contacts with the state of Florida, and the assertion of specific personal jurisdiction does not offend the traditional notions of fair play and substantial justice. Defendant Corporation is subject to Florida jurisdiction because it knowingly and intentionally caused, allowed, and encouraged for clear profit motives for its program to be downloaded and used in Florida. The motion to dismiss should be denied for 3 reasons. The first being, defendant purposely availed itself to the state of Florida through its interactive commercial website, encouraging Florida residents to download its services.
Counselor, what test do you use for that?
Well, there's a few tests you can use. You can use Zippo. The Zippo test judges the websites based on interactive, active, or passive. In this situation, this is an interactive.
What court is that case from?
That is actually used in Goldberg Marketing Group, and that's a case where there was
What court?
the 11th Circuit.
Okay. It's an 11th Circuit court, an appellate court?
Correct.
Okay.
Well, in Goldberg it was used, and the issue was a website, as our current situation, but the only difference was this website was passive, in that the website only contained a phone number. You could not make any contact with this website. No sales were able to be done on this website. As in our situation in Quicksend, which is why we believe purposeful availment, our website, you download programs. This is for business purposes. This is all commercial basis.
So this case worldwide is an 11th Circuit court case that adopts the Zippo test?
Correct.
Okay.
And as in our such situation, as I said, this is interactive. The whole purpose of this website is money. Our client.
The purpose of the website is money?
Correct.
They've only made $27,000.
You have to remember that in order to become a successful website as they intend, everybody has to start out somewhere. They are on the rise. They were just in the beginning of their website, of their business. In a few years, they will be on the rise and will be making more money.
When your client had the issue, had he downloaded the free one or had he paid for his version?
He downloaded the free.
So the company offers free versions?
Correct. But those free versions are used for advertisement. There is a price to pay.
How so?
The price to pay is the very fact when my client uses this website for his clientele, that is advertising for Quicksend. Every single time an email is sent out, that's more availment to those people. That's more advertisement. They can now avail themselves in my situation, my client's situation. There's witnesses in Florida. There's witnesses in Texas. There's witnesses in New York. These people now know about Quicksend, and if it wasn't for my client, their website would have never even gotten into those states.
But we're being asked, what you're asking is that we subject Quicksend to liability for something that they weren't even paid for. They weren't even paid for this
Correct.
download.
Correct.
So why should we subject Quicksend to the jurisdiction of this court when they didn't really even make any money from this transaction?
It's not about the money. It's about the fact that they avail themselves to Florida. My client is in Florida. My client's business is in Florida.
What do you have to say about the fact that if we do this and allow for Quicksend to have to come here to have a trial in this case, every time somebody complains about Quicksend, Quicksend's going to have to travel all over the country?
Quicksend is free to place a forum selection clause on their website, which they did not do. If they don't want to be availed to every single state, place a forum selection clause on there. With them not doing that, they, you know what, if a Florida resident, if a New York resident does use their website and a controversy occurs, yes, they should travel. It is their responsibility. They are choosing to do business with the state. Based on them choosing to do business with Florida, based on what occurred, based on their website, they have established purposeful availment. And I'd like to move on to reasonably being hailed into court. They should reasonably be hailed into court, first of all, because the forum selection clause was not selected, as I said before, and an
Do you have
intention.
case law that states
I do.
that? Or
Case law is Carnival Cruise Lines versus Shoot,
what court is it?
11th Circuit. And in this case, there was a forum selection clause in the contract with Carnival. And when these people came from Washington, they got injured, and when they raised the issue, the court said they had to come to Florida based on the forum selection clause. If Quicksand does not want to avail itself, they should put a forum selection
How
clause.
did purposeful availment happen in that case? What did they do? What did the court say about purposeful availment? What contacts did they have?
They used Carnival Cruise Line. They booked their reservation, and that was the availment. They're then booking the cruise with Carnival, and it's Miami Corporation.
Okay. So they booked it, just booking it, okay.
They should reasonably be held into court because they intentionally communicated with a Florida resident. Let's remember here, there are 25 downloads. This is not the first instance that they have communicated with Florida. This is a constant basis. They want Florida residents in their business.
Counselor, do you have records of how many downloads they had in other states to show that they picked Florida as an area of advertisement?
I do not, but the very fact that they have an internet and Florida residents can use the website, that shows that, you know what, they want to do business in Florida. If they don't want to do business in Florida, knock it off. Don't have Florida included. Have people put zip codes. Have Florida zip codes discarded from this. You do not need Florida
But
residents.
if we say that they can do that and not be, in order to not be liable, they'd have to do that in every state they did business in, and then wouldn't that make their business, they wouldn't have any business, right? Because they would, in order to never be liable, they would have to just eliminate every state from their business.
I'm sorry, can you repeat the question?
Well, if you say, put a forum selection clause so that they can't be held liable in Florida,
Mm-hmm.
and what effect is that going to have on the rest of their business? They're going to be liable in every other state, right?
No, if they put a forum selection clause on their website, it would say that all controversies that occur happen in California. That if people choose to avail themselves to their website, they have to travel to California if controversies rise, such as Carnival versus Shoot did. Carnival put the forum selection clause on there and said, all controversies, you come to Florida. That's the same thing Quicksand should do, which they did not. And that is why they should come to Florida for the
Do
case.
you have for the forum selection clause?
That's Carnival Cruise Lines versus Shoot.
How exactly did Quicksand advertise to the Florida residents? Did they send out emails trying to solicit business, or was it just a website that people could go on and find through Google?
A perfect example of how they did avail themselves to Florida residents is my client's situation. My client, one of his clients, is a Florida resident. By my client using a confidential file to be sent to his client, Quicksand has now availed themselves
That's
to
not
my
the
client's
question,
client.
Counselor. The question was, how did they advertise to the Florida residents? How exactly did they advertise to Florida residents? You
By being
claim-
on the internet.
So
Once you're on the
purely
internet,
having a website that anybody can access means that you are advertising to each and individual state.
correct. As in Zippo, it's an interactive website. Being interactive, you know what? You want business. You are promoting business. By putting yourself on the website, you're expecting business. This was done intentionally. They are not doing this business for their goodwill. They are doing this because they want to make money. My client has been injured due to their business. Third, any real interest on the plaintiff and real interest on the state will outweigh the burden on the defendant. Florida should hear this case. It belongs in this court. This is a Florida business. This is a Florida resident. Quicksand has availed themselves 25 times to Florida. This can happen to future residents. This can happen in the future. My client's business, my client's reputation, my client's livelihood is through. He has $200,000 now that he has lost because of
What case do you
Quicksand.
have to support the fact that this Florida's interest, because of this one business and this one client, is enough?
Morris versus SSE. In that situation, one item was brought into the state of Alabama. And because that one item was brought into the state of Alabama, that was enough for them to have
What
an
was
interest
that
in it.
item?
I'm sorry?
What was that item?
It was actually a defective parachute.
Okay.
How was it brought into the state?
It was a defective parachute, and a local store saw that it was defective. They sent it back to the manufacturer who was located in the New York area. The New York area took the defective product, fixed it, and sent it back. The very fact that they communicated, such as Quicksand did with my client on 4 separate occasions via email, shows the purposeful availment. Listen, defendant corporation is subject to Florida jurisdiction because it knowingly and intentionally caused, allowed, and encouraged for clear profit motives for its programs to be downloaded and used in Florida. This motion to dismiss should be denied. Thank you.